Did you have a good break? Yeah. Yeah, it was all right. It was good. I did. Yeah. I think people are sick of me, so I think if people are sick of me, I think we're done for a while.
EventID is going to speak about Bob Scott.
Okay. The Rules Committee will come to order. Today, this committee, Today, this committee will be considering two measures. Let me speak to the first, H-Res 124, since Chairman Smith is unable to attend this meeting. This resolution, introduced by Congressman Kennedy in February, is in response to the President governing by tweet in July 2017. That's when President Trump wrote seemingly out of nowhere that he would be banning transgender people from military service. That would revert us back to the decades-old discriminatory policy that was lifted in 2016. In ending that ban, the Secretary of Defense, Ash Carter, said, and I quote, "We don't want barriers unrelated to a person's qualification to serve preventing us from recruiting or retaining the soldier, sailor, airman, or Marine who can best accomplish the mission," end quote. I think that's something that we should all agree with. President Trump's ban flies in the face of the findings released by the Pentagon after a year-long working group recommended the 2016 policy change to ensure that we recruit and retain the best possible service members. That is why 56 retired generals and admirals, along with Democrats and Republicans here in Congress, have condemned the move. Transgender troops have been serving in our military for a long time. They have willingly deployed into combat zones and put their lives on the line to defend this country, hundreds alone since the policy was changed in 2016. They have not asked for or received any special treatment, no exceptions of any kind. They have been held to the same standards as all other troops. They have served honorably, and they deserve our thanks for their service, not to be forced to serve under a cloud of stigma or prevented from serving at all. H-Res 124 would put Congress on record as rejecting this arbitrary ban and the flawed science behind it, while urging the Department of Defense not to implement it. There is currently legal action against this proposed ban, which is moving through the courts on its own course. But if nothing is done while it is challenged in the courts, then this ban could be enforced for the first time as early as next month. So I would hope that we learn something from the failed don't ask, don't tell policy. Unnecessarily stigmatizing a whole class of people is bad policy that negatively impacts our readiness and weakens our military. And so I'm proud to stand with these troops and against the President's policy and what I believe is cruelty, quite frankly. The second measure before us today is H.R. 7, the Paycheck Fairness Act. The sad reality is that 56 years after Congress took action to ensure equal pay for equal work, the gender wage gap persists. Women make only 80 cents on average for every dollar earned by a male counterpart. That gap is even more pronounced for women of color. This infests every community in every state in the nation. When a woman is paid less than a man for doing the same job, it cheats her entire family. Children feel the impacts. There is less money to save for retirement. Poverty increases, and I can go on and on and on. This bill empowers workers, holds employers accountable, and gives the Department of Labor the tools it needs to enforce the Equal Pay Act. Every member of the majority has co-sponsored this legislation, and I'm proud to support it. It is past time to ensure true equality for every working woman in America. I want to recognize Chairwoman DeLauro's continued leadership on this issue. She first introduced the Paycheck Fairness Act in 1997 during the 105th Congress. She never gave up the fight through all those years. We wouldn't be here today working to advance this bill to the House floor without her tireless commitment. So before we hear from our witnesses, let me turn to our ranking member, Mr. Cole, for any remarks he wants to make.
Thank you, Mr. Chairman. I appreciate that very much, and want to address both these issues. And just in passing, I want to make a point where I know we agree, which is I want to thank all of our current service members and those who are thinking about answering the call to serve, and I applaud and appreciate any person, regardless of their gender or how they identify themselves, who wishes to serve the country. I've got some other remarks on that, but I'll just submit them for the record in the interest of time. On my good friend's bill, and it's good to see my friend here. I want to thank you, Mr. Chairman. We're here today to discuss a bill that has a noble goal to ensure that all employees receive equal pay for equal work. And while we don't always agree on things, I think every person in this room, Republican and Democrat, can agree this is a good goal. And I think we agree that the law should provide protections ensuring men and women receive the same pay for doing the same work. But there are already laws on the book guiding this very issue. In fact, it's been the law of the land since the Equal Pay Act was enacted in 1963, and the bill before us today does not add any significant new protections or make it more likely that women and men will actually receive equal pay for equal work. Instead, all the legislation does is create incentives for, frankly, unscrupulous trial lawyers to file more and more lawsuits and personally profit as a result. H.R. 7 adds provisions that would allow plaintiffs to seek unlimited punitive damages against employers and would make it nearly impossible for any employer to defend itself in litigation. H.R. 7 makes it easier to certify classes and class action lawsuits and takes no steps to ensure damages actually go to the victims of discrimination. In short, it's a bill written by trial lawyers for trial lawyers to ensure greater and greater paychecks to trial lawyers. And since my friends know this bill is going nowhere in the Senate, it's yet another political messaging bill, plain and simple. Mr. Chairman, I believe my friends on the other side have their hearts in the right place. But if the Democratic majority truly wanted to achieve this goal, shared by Republicans, then I would encourage the majority to work with us on legislation to actually improve the Equal Pay Act, to improve its enforcement, and to ensure that all workers are protected. With that, Mr. Chairman, I yield back my time.
Thank you very much, and I would now like to call up our witnesses, Vice Chair Levin, Mr. Byrne, and Mr. Lauro is already up here. We're delighted that you're here. Anything you brought in writing will be entered into the record without objection. Oh, and Chairman Scott is here as well. Okay. We're doing one, Mr. Chairman, do you want to come up? Because I think we're doing one panel here. Yeah. That's about a fair fight. Yeah. All right, so I think Mr. Scott will begin with. Oh, Mr. Levin, the Vice Chair Levin, go right ahead.
Thank you, Chairman McGovern and Ranking Member Cole. In 1963, the Equal Pay Act codified the right to equal pay for equal work regardless of sex. In fact, the Equal Pay Act was enacted 1 year prior to the Civil Rights Act of 1964 that, for the first time, provided for the enforcement of anti-discrimination laws. Over the past 55 years, the Equal Pay Act, in combination with the Title VII of the Civil Rights Act of 1964, has led to substantial progress in addressing inequities for women in the workplace. Yet loopholes and insufficient enforcement have allowed gender-based wage discrimination to persist. Today, women earn on average 80 cents on the dollar compared to white men in similar jobs. The wage gap is even worse for women of color, and it exists across every sector, regardless of education, experience, occupation, industry, or job title. This inequity has severe consequences for working women, families, and our economy. Drawn out over a lifetime, the persistent wage gap could cost a woman anywhere from $400,000 to $2 million. For many, this is the difference between financial stability and poverty. In fact, we know that achieving pay equity would cut the poverty rate for working women by more than half. Working women make up the largest share of our nation's family breadwinners. Today, 64% of mothers are either the sole family breadwinner or the co-breadwinner. Research shows that if mothers earned equal pay, approximately 25.8 million children would benefit from the increased earnings of their mothers. Finally, the wage gap withholds $500 billion each year from nearly half of our nation's workforce, money that could be spent at small businesses and in our local economies across the country. Workplace rules that restrict sharing information about wages and pay raises often keep working women from holding employers accountable for discrimination. Despite current protections, the lack of wage data transparency makes discrimination difficult to detect, let alone prevent. That is why the House Committee on Education and Labor made it a top priority this year to put the Paycheck Fairness Act on the floor. This bill would combat gender-based wage disparities by strengthening the enforcement provisions in the Equal Pay Act of 1963. Specifically, it requires employers to provide that gender-based pay disparities are based on bona fide job-related factors, relevant education, training, or experience, that are consistent with business necessity rather than on unrelated factors that mask pay discrimination. Additionally, it eliminates barriers that prohibit workers from discussing their wage or salary levels, strengthens the ability of women to take collective legal action against systemic pay discrimination, improves wage data transparency, and helps businesses improve equal pay practices. The Paycheck Fairness Act finally aligns our treatment of gender discrimination with other established anti-discrimination policies. The changes to remedies made under H.R. 7, namely eliminating caps on damages when employers act with malice or reckless indifference, are consistent with the laws governing discrimination based on race or national origin. The provisions in H.R. 7 regarding attorney's fees are consistent with Title 7 of the Civil Rights Act. And H.R. 7 restrictions on employers' inquiry and reliance on a prospective employee's previous levels of pay conform with restrictions imposed under other non-discrimination laws. This includes the inquiry and reliance provisions in the Americans with Disabilities Act and the Genetic Information Non-Discrimination Act, and analogous to restrictions on an employer's consideration of an applicant's pregnancy status or intent to become pregnant. While gender-based discrimination is already illegal, women in the workplace simply do not have the same protections from workplace discrimination as other protected classes of people. That's why during the 110th Congress, this chamber passed a previous version of the Paycheck Fairness Act on a bipartisan basis. In the 116th Congress, we once again have the opportunity to ensure that discrimination based on gender is treated on an equal footing with discrimination based upon race and national origin. It's an opportunity to realize equal pay for equal work that we simply cannot afford to miss. Thank you, Mr. Chairman.
Thank you very much, Mr. Byrne.
Thank you, Mr. Chairman, and it's good to be back. I appreciate the opportunity to speak about H.R. 7 as a former Rules Committee member. I know just how much you appreciate brevity, so I'll get straight to the point. The Paycheck Fairness Act is built on the false promise that in some way it helps women. It does not. This bill is for and about the future of trial lawyers and not working women. Pay discrimination is repugnant and illegal. Let me say that again. It is repugnant and illegal. We must hold bad actors accountable. And I say that as the grandson of a working woman, the son of a working woman, the son-in-law of a working woman, the brother of a working woman, the husband of a working woman, and the father of 2 working women. This bill just doesn't do that. Instead, what we have before us is just another mandate. We have one of the most varied and complex workplaces in the world. We're striving towards more diversity in all areas of American society, and especially the workforce. Women are claiming paychecks today in record numbers. So why would we turn around and force a one-size-fits-all approach moving forward? I don't see how limiting the discussion between employers and employees, particularly on hiring decisions, is going to help anybody. I don't see how opening the gates to limitless, frivolous lawsuits is going to help anybody. And I certainly don't see how the federal government is going to help anybody learn how to negotiate better. I would note for the committee that the Lilly Ledbetter Fair Pay Act was signed into law 10 years ago with the promise that it would alleviate pay discrimination in the workplace. And yet, if you look at pay discrimination charges filed with the EEOC, they have remained relatively steady each year since 1997. In fact, they haven't changed much from before that time, during that time, and today. I'm hearing the same kind of overpromising when it comes to H.R. 7, like this is going to move the needle, and it's not. Sex discrimination cases are serious and deserve to be treated with seriousness. We need to focus on policies that will create more opportunities for women and all workers in the first place. The original bill doesn't do that, and none of the changes we saw in committee does that. This bill is a trial lawyer's dream, and I'm offering 2 amendments that would go a long way in strengthening the law itself and keeping potentially predatory lawyers honest. The changes to the Equal Pay Act in H.R. 7 would make it extraordinarily difficult, if not impossible, for employers to defend against pay discrimination suits, even when pay differences are the result of legitimate factors like experience, education, and performance. This was my area of practice for over 30 years. I have defended these cases. I've had women come to me to ask me to give them advice on these cases. And I can tell you that under this law, judges and juries are not only not hostile, they are open to these claims. In fact, unlike Title VII, you don't even have to prove what we call scienter, that is, the mental state of the actor. You can simply show that there's the effect of it without showing any intent. That's very unusual for discrimination cases. Mr. Chairman, I'd like to, if I may, briefly comment on the two amendments I filed with the committee. The first would strengthen the Equal Pay Act by adding the language bona fide business-related reason to make it clear to the courts that factor other than sex defense currently in the law cannot be used as a loophole or excuse for using sex as a factor in determining pay. This would make the language consistent with how most circuit courts of appeal have interpreted it. H.R. 7, as written, would impose unworkable and untested concepts on employers, making it impossible for them to defend any difference in pay, even when those differences are based on any number of legitimate job-related factors. Instead of treating sex discrimination charges with the seriousness they deserve, H.R. 7 makes it easier for lawyers to pursue lawsuit of questionable validity for the purpose of siphoning off unlimited paydays from settlements and jury awards, lining their own pockets, and dragging their clients through tedious, never-ending legal dramas. H.R. 7 would be a cash cow for lawyers working on a contingency fee basis, some of whom get 40% or more of their award. That brings me to my second amendment, which is a simple 20% cap on an attorney's contingency fee. I offered a similar amendment during the committee markup of the bill, which would have limited contingency fees to 15% of the judgment. After hearing complaints from my colleagues on the other side of the aisle that 15% was not enough compensation for trial lawyers, I wanted to adjust the limit to meet their concerns by increasing it to 20%. Supporters of H.R. 7 insist that this bill is about helping the victims of pay discrimination. So they should like this amendment, which would make sure that the victims see more money at the award in these cases and not their lawyers. These amendments are common sense. If supporters of H.R. 7 really care about victims of pay discrimination, they'll see merit in both amendments. Therefore, they should be made in order, and the entire House should get a chance to vote on them. And I'm happy to answer any questions. I yield back.
Thank you. Mr. Laurel?
Thank you very, very much. I'm really very pleased to be here today. I want to say a thank you to Chairman Jim McGovern for the opportunity to testify about the Paycheck Fairness Act, and a thank you to Ranking Member Tom Cole, my longtime partner on Labor, Health, and Human Services and the Education Appropriation Subcommittee, and to all of the members of the committee. I'm delighted to be with you. I also want to recognize Chairman Bobby Scott and the members of the House Education and Labor Committee, and that is Mr. Levin, who's here, Mr. Byrne, but to the committee who have helped us come so far. This moment represents a significant milestone for women in the workplace, and I think we should all be very, very proud. For more than 2 decades, we have pushed and battled to strengthen the Equal Pay Act of 1963. We launched side by side into the fray to elevate pay discrimination, to emphasize how central its impact is to working families. I cannot tell you how difficult it has been to break through on something so simple. Men and women in the same job deserve the same pay. It's a principle that we adhere to in the Congress. And I might add, we adhere to it in our military. Now the issue and the environment have collided. The House just welcomed the most diverse class in its history, including the most female members ever. And equal pay is at the center of the discourse. The Paycheck Fairness Act, which has every member of the Democratic caucus signed on as co-sponsor. And I might add, 2 Republicans, that's Congressman Chris Smith, who just sent out a Dear Colleague letter urging members on both sides of the aisle to support the Paycheck Fairness Bill. Chris Smith has been there every step of the way. The act would toughen the remedies in the Equal Pay Act of 1963 to give America's working women the opportunity to fight against wage discrimination and receive the paycheck that they have earned. Whether through the Equal Pay Act or through Title VII, current law makes it difficult for women to proceed with equal pay cases. Even if a case proceeds and women are awarded a legal victory, the damages are often insubstantial, providing women with little compensation and employers with little deterrent from practicing future wage discrimination. Some claim the wage gap is a myth, yet women continue to earn 20% less than men on average, according to census data, and women of color suffer most acutely. Black women make 61 cents and Latinas make only 53 cents on average on the dollar when compared to white, non-Hispanic men. I won't take your time, but I have several pages of documentation that talk about the various industries. In fact, you go down the line, whether you're securities, commodities, financial managers, retail, salesperson, you can go through this. It's 10 largest occupations for women, 10 largest pay gaps for women, and on and on. This is not a one-off. This is consistently in industries in this nation who hold women hostage. Over a career, women can lose over $1 million. We also recognize that the lack of pay equity translates into less income toward calculating pension, retirement, and in some cases, Social Security benefits. Opponents also claim that women who are underpaid are free to find another job. But women having to flee jobs because of discrimination is not the answer, especially when they may not know for years that their wages have been tainted by discrimination. Changing job places the burden on those who have been victimized and is certainly cold comfort for those in areas where job options are limited, for those who are living paycheck to paycheck with no cushion to be able to look elsewhere. We need to give workers new tools to challenge discrimination and deter employers from violating the law. Others insist that the 20% figure does not take into account education and experience. But the truth is that the gap barely closes among women with college degrees. Research by the American Association of University Women found that just 1 year after college graduation, women earn only 82% of what their male counterparts earn. And when controlling for a variety of factors that influence earnings, there still remains a 7% unexplained wage gap. Take a look at the Congress, my friends. Men and women, different parts of the country, different philosophies, different education skills, a whole range of issues that are stated here that doesn't take into account education and experience. We have different education and experiences as members of the Congress, and yet men and women here are paid the exact same amount of money. And the fact is that after 60 years, after President Eisenhower called for equal pay legislation, this is what he said: legislation to apply the principle of equal pay for equal work is a matter of simple justice. And more than 55 years after President Kennedy signed the Equal Pay Act, pay discrimination is still very much a reality in our country. In 2017, there were 25,605 charges of unlawful sex-based pay discrimination with the U.S. Equal Employment Opportunity Commission and 996 Equal Pay Act charges. Of course, by now we are all familiar with the case of Lilly Ledbetter. Her bosses said, and I quote, "Their plant did not need women, that women did not help, and in fact, they caused problems." Well, a jury found that yes, Lily had been discriminated against and awarded her $3.8 million in back pay and damages, which, by the way, would not have been allowed under Title VII, which caps the amount of money at $300,000. But even further than that, when Goodyear took this to the Supreme Court eliminated all of the damages. Lily Ledbetter got zero, as it closed the courtroom door to all women. We, the Congress, reopened that door with the Lilly Ledbetter Pay Act, which reversed the Supreme Court's decision. It was a court access case. It did not address the underlying issue of pay discrimination. It is a systemic discriminatory barrier, and just as our country has done to bring down other discriminatory barriers, we must use the collective power of the American people in the form of the U.S. Congress to ensure women have the power to gain economic security for themselves and for their families. Under the Paycheck Fairness Act, any employee can sue for compensatory and punitive damages without facing the arbitrary caps that they face under Title VII. The bill would also protect employees from retaliation for sharing salary information with their coworkers, and it would establish a grant initiative to provide negotiation skills training for women and girls. Let me also be clear about what the bill does not do. It does not eliminate key employer defenses against claims of discrimination. The bill simply makes clear that when an employer states that its pay scale is informed by a, quote, factor other than sex, that must actually be true and not just an excuse to continue discriminatory practices. H.R. 7 merely restores Congress's intent, which has been undermined by court interpretations over the years, allowing employers to escape liability in cases in which their decisions were in fact based on sex. Again, I thank the committee for this opportunity to testify and for addressing this critical issue. When President Kennedy signed the Equal Pay Act over 55 years ago, he said that it would, and I quote, add to our laws another structure basic to democracy, and, quote, affirm our determination that when women enter the labor force, they will find equality in their pay envelope. We twice passed paycheck fairness in the House of Representatives in 2008 and in 2009. But now in and it was bipartisan, I might add. But now in the 116th Congress, in which we welcomed the most women in our history, we must get it into law. We have the opportunity to make good on the promise that presidents of both parties have made. Let us seize the opportunity. I thank the committee.
Thank you very much. And Mr. Scott, I understand you don't have an opening statement? Or?
Let me just make a couple of comments.
Okay.
So we can get to questions. One is, my colleague has pointed out, women still make significantly less than men. This bill will conform many of the discrimination procedures to others. What you can get in a case based on race, religion, you ought to be able to get based on sex. Especially the caps on damages. You can get a lot more in cases, and it just conforms those. We've heard the old saw about lawyers might make some money. Well, if that argument was used on Medicare, you shouldn't have Medicare, because all that happens is the doctors get a lot of money. No, the doctors are providing the service, and the benefit goes to the people. If somebody brings a case, they're going to need a lawyer, and this means they can bring the case. If you limit attorney's fees, all you've done is shut the courthouse door on people, because if you got a small case, no lawyer's going to take it, and person can't get to court. The Lilly Ledbetter was a very specific problem in the law that occurred when someone didn't know they were being discriminated against for years. They finally discovered they've been discriminated against. What the court decided in that case, in cases that don't have the discovery rule, was that the statute of limitations had run on the decision to discriminate, and the case was over, just based on the statute of limitations. And it was even so bad that since the decision is made earlier, they could continue to discriminate without any recourse. I said, yeah, no, you're paying less than men, and we're going to keep doing it because we have been doing it for more than the statute of limitations, and we can keep doing it. And you have no recourse. The Lilly Ledbetter Act essentially created a discovery rule that if you discover you've been discriminated against, all the paychecks within the statute of limitations constituted active discrimination. That just, as Representative DeLauro said, just gives you access to the court. With those, Mr. Chairman, we can get to questions.
Well, thank you very much. I want to thank all of you for being here, and I don't have any questions. Mr. Hastings, do you have questions?
No, I have no questions, but I'd like to make just a very brief comment complimenting Ms. DeLauro. I was here with her in '08 and in '09, and I'm delighted that I'm here with her now. I did want to quarrel with her about one thing. I am delighted that women and men make the same thing that serve in the House of Representatives, but I, for one, don't believe they make enough. Thank you.
Let me ask unanimous consent to insert in the record a statement of Congresswoman Waters and Sheila Jackson Lee. Mr. Cole.
Well, I want to begin by associating myself with my good friend, the Vice Chairman. And just a couple of quick questions, if I may. Chairman Scott, obviously, we all agree on this in terms of the basic principles there that discrimination on the basis of sex, or frankly, any other kind of category we want to use, is just inappropriate, and equal pay for equal work ought to be the law of the land, has been actually for a long, long time. Doesn't the 63 Equal Pay Act, specifically already achieve this objective? And if it does, and you make a good point in terms of the appropriate level of damages, I mean, why wouldn't we look at amending that law just to allow for some sort of appropriate increase in that?
That's what's in the bill.
I know, but that's not all that's in the bill.
Well, let's talk, well, one problem you get into in a lot of pieces of legislation is you start arguing the title and don't get into the provisions. The provision you indicated is in the bill. There are other provisions. You have the cap, you have the ways you can bring suit, the standard. It tries to conform the law into the other forms of discrimination. And as you pointed out, it doesn't make discrimination against women illegal. That's already illegal. But it just makes it easier to bring a case.
What are the problems? I mean, as you mentioned, I think, and my good friend, the gentlelady from Connecticut, mentioned, obviously, House passed legislation in 2008 on this sort of thing. Didn't get very far in the Senate. I'm just curious, frankly, what were the problems? We had a strong Democratic control in the Senate at that time. What were the roadblocks? If you recall, if you don't, that's fine.
I don't remember.
Certainly directed to my friend.
Sure, thank you very, very much for the question. I also might add, the issue where we amend the bill is one of the unwritten laws has been, Congressman Cole, has been this pay secrecy. Oftentimes, as Lilly Ledbetter was, when she went to work for Goodyear, she had to sign something that would say that she couldn't have a conversation with a fellow employee about her salary. Now, that's true for men and women. That still exists. And what this does, President Obama lifted that with regard to federal contractors, but it still exists. You can be fired for you and I having a conversation about salary. So, and that's wrong. So we put an end to that. But to your question of the Senate, if I might, I said we passed it twice in the House, and it went to the Senate. It actually was supposed to. I'll give you the details. It was supposed to go to the Senate in tandem with the Fair Pay Act. There was a decision to separate it out and to go separately. And when it came to doing the Paycheck Fairness Act, we lost by 2 votes. I'll tell you very quickly, we lost 2 votes. 2 Republican women in the Senate voted against the bill. Otherwise, today, it would be the law of the land. And then the second time around, it just got caught up in the politics of the institution and so forth. So there should have been no reason why this could not be the law of the land today, and not find out the first time we were ever able to, when I introduced it in '97, and we were in the minority, 12 years before it had a committee hearing. When we did win in 2006, George Miller took the reins of the committee, and that's when we passed it, went through the committee. We then now have waited an additional 8 years, and with Congressman Scott as chair of the committee, we are once again able to debate a bill which has been a very long time in coming, and we have an opportunity to pass it.
If I may, Mr. Byrne, I mean, this is obviously an area you have considerable expertise. As you pointed out, you practiced in this area for 30 years. I assume the legal framework we have should be sufficient in many ways to achieve this objective. What are your chief concerns here about this particular piece of legislation?
Well, Mr. Laurel brought up the judgment in the Lilly Ledbetter case, which was tried in Alabama. And the jury rewarded a huge verdict. So that's what I meant previously when I said that judges and juries are not only not hostile to these claims, they're very open to them. And I can tell you as a practitioner, when these claims came forward, I never once said to myself, oh, this is an easy case. They were almost always very difficult cases. So I think these are the sorts of cases you would normally see come forward and would be taken very seriously by judges, juries, and lawyers. The thing that stands out to me is the low number of filings. And as I say, they didn't increase after Lilly Ledbetter, which was the law, which was designed to try to make it easier. For some reason, women are just not filing these claims in the numbers that a lot of people would expect them to see. Now, we didn't have any hearings on why that's the case in committee, so I can't give you any, informed answer on this, but I could give you some conjecture based upon my practice. I think a lot of women don't know about the law. I think that's a problem, that we need to educate women in America more about the law. I don't think women understand that there's protection for them if they come forward with this claim that they can't be retaliated against, because I think there's some women that may know that there's something out there to protect them, but they're scared to come forward. And so I think if we dealt with some public education there, that could be better. The problem here is that the standard they're using, I think, is totally amorphous. And what will happen is that we'll spend years, if not decades, with the courts wrangling through what that very amorphous standard is. The standard that I proposed in my amendment is a very clear standard that we know what it is, because we've had a number of circuit courts that have defined it for us. And I think that would be better for both plaintiffs and defendants alike to have an understandable standard. But the way that they've got this put together in this bill, it would make it virtually impossible for an employer to be able to offer the defenses that you would expect an employer to offer, which is, I made the decision on this pay based upon their experience or education. Now, my colleague may not think that education experience is important to an employment decision, but I think anybody who's ever dealt with this, including professionals in this area, HR area, would tell you that education experience is extremely important. Now, there are other factors as well. You want to see performance, et cetera. But particularly when you're doing an initial hire, all you've got really is education and experience, because you don't really know what their performance is if they work somewhere else. So I don't think that this bill gets to the central problem, which is we don't have women with the understanding of what they need to have the understanding of to be willing to come forward and file these claims. Because if they do, they've got a very willing judge and very willing jury in virtually every case.
One of your amendments, both of which I support, by the way, and I hope they're made in order, obviously caps attorney fees at some percentage of the award. Again, that seems reasonable to me, but I think Mr. Scott makes a very good point as well. I mean, people have to get paid. Are you worried about abuse in this area that might hurt the client?
Yeah. Yeah, I do. First of all, there are plenty of lawyers to file these lawsuits. I know many of them. They're good friends of mine. They're excellent lawyers. And they would love to have people come to them and present to them a meritorious case that they can bring to the court, because that's how they make money. They'd love to see them. I do think that if we're going to protect women here who bring these cases, we need to protect them from lawyers that will get them to sign a contingency fee agreement that takes a big chunk of the award away from them. So if we're really concerned about working women who've been discriminated against, let's protect them from the lawyers that would take advantage of them. And I don't think a 20% cap is going to keep a lawyer from taking this case. I can guarantee you, even with a 20% cap, there are plenty of lawyers out there that would take a case if it's meritorious. And so, number one, we need women to come forward. Number two, they need to come forward with meritorious cases.
Oh, certainly.
Thank you.
Mr. Chairman.
When you limit plaintiffs' attorney's fees, you're talking about access. Because if you're set at a level at which no lawyers will take the case, you can't bring it forward. And you don't hear any limitation on defense attorneys. They have a financial interest in dragging the thing out, not settling. The longer it lasts, the more they make, because they're on an hourly rate and they're getting paid whatever happens. And when you limit the attorney's fees on the plaintiff side, if it's a small case, nobody will take it. It's just as simple as that.
Is there any level that would be appropriate, or you just think that should
And
be?
reasonable attorney's fees, and that's what the courts, judges have been working with. They know what's reasonable and what's unreasonable, and they can set it. If it's a small case, I mean, these are complicated cases. You got a lot, it's not like a run-of-the-mill case where you go in and file a couple of motions and you're finished. These things can take a lot of depositions, a lot of witnesses. A lot of them have to go to trial. They're not easy. They're complicated. It's an automobile accident. It's pretty straightforward. One guy had the red light. Either he had the red light or he didn't. These are complicated. You've got a lot of different issues you're talking about. And the idea that experience and education are not bona fide factors for setting salary, that's not. The bill doesn't eliminate that. But you can't have all the college-educated men getting credit for being college-educated and not give the same credit to women. And if it's the same experience, you got a longer experience, men and women have to benefit from the same thing. If all experienced men get a little extra, they get a little college education, they get a little extra, all the college-educated women don't get that same extra, that's discrimination. But the problem with limiting an attorney's fees and doing something other than what is reasonable. And the court has cases every day where attorney's fees are an issue. And some cases go on appeal, and the only question on appeal is the reasonableness of the attorney's fees. So, I mean, it's not like this is something new. And it's not just in these cases. Any case where attorney's fees are part of the recovery, reasonable attorney's fees can be assessed. But if you set it low enough, you're talking access. And that's why these limitations on attorney's fees are so attractive to defendants, because if they can limit the attorney's fees on the other side, they drag it out long enough, and you're only getting a little bit of fee, you're in the hole just on expenses after a little while, and you'll stop taking these cases unless you can get reasonable attorney's fees. And that depends on the size of the case. If it's 20%, if your recovery is $1,000, you're talking $200. I don't know, I haven't practiced in a long time, but that'll get you a consultation with with a lot of attorneys. But you have to set it at something that they'll actually take it. And if it's $1 million case, 20% is reasonable. If it's a $1,000 case, you're not going to be able to get a lawyer.
Okay, thank you. Did you need to make a comment, Mr.
Can I just wanted to add that there's not a single organization that defends women's equity and their rights in the workplace that favors. The only people who favor limits on attorney's fees are people who represent the employers who are or are not discriminating against women. There's no organization that defends women's rights that supports the idea of capping fees.
Do you care to
I
respond,
would like to
Mr.
speak to that. These cases unless their class actions are really not complicated. If it's a single plaintiff or a couple of plaintiffs, they're actually pretty simple. And the lawyers that specialize in this area, they have the expertise. They know when they come in the door, this is what I got to prove in this case. And I heard my colleagues said about defense lawyers like me dragging out cases. My clients got very upset with me if they thought I was dragging out cases because they didn't like paying the extra attorney's fees. So there was a lot of heat on me to try to get it resolved. In my experience, these cases took about a year. And the discovery was pretty simple because you're talking about an employee and maybe some data about the other employees who are similarly situated in the workplace. So typically, you might take a couple of 3 depositions. Mainly, the discovery goes off on interrogatories, request productions of documents. And the only reason it took as long as a year is that the court's docket was such that you couldn't get to it in a year because that's just the way they were scheduling things. These are actually not hard cases to make if you've got a meritorious case. Now, if you're scratching around trying to take a weak case and make it into a good case, that might take a lot of work. But if you've got a meritorious case out there and you know what you're doing, you can do this, and a 20% attorney's fee would be a nice fee. I mean, a typical award in one of these cases, from my experience, may be somewhere around $40,000 or $50,000. Well, at $50,000, a 20% fee is $10,000. I don't know about in Virginia, but in Alabama, that's pretty good money for an attorney for a case like this. So if somebody came to me and presented me with a meritorious case and I know I can make $10,000 on it, hey, I might take that case. That might be a pretty good day's work for me.
And if it's a small case, they can't take it. If it's a $10,000 case, you're talking $2,000. You just heard a deposition or 2 or 3. You're not going to be able to find a lawyer taking those kind of cases.
Thank you very much. Mr. Chairman, yield back.
Thank you, Mr. Chairman, and thank you to the panel for joining us here today. A terrible disparity exists in our country today. Almost 60 years after the passage of the Equal Pay Act, women still are not compensated equally for the work that they do. Women are paid 80 cents to every dollar their male counterpart makes. That is true. But for women of color, the gender wage gap is even more severe, and it continues to widen. For every dollar made by their non-Hispanic white male counterparts, so I want to give you some examples. African American women make 61 cents. Native American women make 58 cents. And Latinas like me make 53 cents. I have been practicing in this field too, not as a lawyer, but as a worker since I was 16 years old. In my late teens, I sold stainless pipe valves and fittings. Now, experience and education is absolutely important, and it is key. But I would also challenge that technical skills and bilingual education is also important. So while they were very experienced males in this industry, and it is a male-driven industry, we each got paid a basic pay. And the difference of that was several thousands. But at the end of the month, they would add up all of our sales. And the difference of that was hundreds of thousands at the end of the year for me as a young person. Now, to their disadvantage, they sold in 1 language. To my advantage, I sold in 3 languages. To their disadvantage, they required an assistant to input the data into a computer. If you recall the 80s, computers were being introduced into the work field. To my advantage, I did my own data entry. And sometimes, if I really wanted something out that day, I would walk out to that warehouse and I would pull my own pipes and fittings, and I would package it and ensure that they were delivered to my customer. Those were the skills that I brought. But I knew very early on in that career that if I was going to be a mother, and that if I was going to be able to purchase a home, which I did in my early 20s, I had to leave that job. I couldn't stay there, earning pennies to the dollar. So I did. I left that job. I got another job where I would get paid equal to my male counterparts, where my health benefits were equal to my male counterparts, whether I was a single female or a married female or a homeowner or not. This is how I was able to have a child and to purchase a home early on. Attorney fees are important, and I hate that, that we have to pay attorneys. But attorney fees are important. They're important for your family, too. We only have to look at our prison system and the number of minority people of color that are within our prison system to understand that there is a disparity there, that the system is not equal for everyone, and that it has failed many people that look like me. I've offered 2 amendments to this bill that address the impact that the gender wage gap has on women of color. My first amendment recognizes the harsh reality of the gender gap on women and girls of color. My second amendment ensures that the Secretary of Labor considers the impact gender and ethnicity have in research and education efforts. If we do not measure the impact of the wage gap specifically on women and girls of color, then we don't know the scope of the problem, and it will continue to fail to address it. My amendment will ensure that all women benefit from this progress, regardless of their race or ethnicity. H.R. 7, the Paycheck Fairness Act, should be the beginning, not the cap. And I hope to see this legislation addressing comprehensive paid family medical leave, sexual harassment prevention, and improved conditions for pregnant women, affordable childcare, and much more. So the question that I have to the panel is, what is the cost of the wage differential to children of working mothers? And how many children would benefit from the passage of this law, if any of you know?
I don't have exact numbers for you, but I do know when we deal with a refundable tax credits, which is not the discussion here, we have the ability through that effort to lift 40% of children and their families out of poverty in the country. The biggest economic challenge we have today, as you pointed out, that people are in jobs that just don't pay them enough money. And when we are singularly, in essence, discriminating against women, men and women, same job, same pay, simple premise, that then this is not about women, this is about their families and their children and what, in fact, they are not able to provide as a family to be able to achieve economic security.
I don't have any numbers either, but I want to respond to the first part of what you said. You make a great point. I mean, education experience is not everything. And employers should be looking at a number of factors so long as they're directly related to the performance of the requirements of that particular position. So one of the problems that I have with the way that this bill is authored is it's got this factor other than sex. Well, if you put in bona fide business-related reason, then you're forcing the employer in the defense of the case to come forward and say, why is this a bona fide business-related reason better than these other factors? So the ones you brought up, bilingual, have certain technical skills, you input your own stuff, you go get your own, you're showing some levels of value to the employer, another bona fide business-related reason, that is pretty clearly understood by everybody when you go to court. If you have something like factor other than sex, who knows what that means? But I think by adding my amendment, I think we actually get to your point, but it also points out this. employers are going to have to use different types of understandings of what they're looking for in employees depending upon the position, sometimes depending upon where that particular part of the employer's business operates, because they're different in different places. You can't have a one-size-fits-all type imprint here and expect it to work everywhere, because you're going to have positions just like the one you had, where you're going to have some peculiar things there that that employer should be considering and may not be.
Many times, and later I learned that this was part of my problem in that industry. I was 19, 20 years old. I could not go to a bar and rub elbows, like the guys could. So when I turned 21, that was not an option for me either because of safety issues and precautions that I felt I needed to take as a female in the workplace. I really want us to think about when we talk about supporting families and the family unit, we need to think about the fact that too many women nowadays are the heads of their own household. So they are paying the rent, they are bringing the groceries home, they are cooking, they're doing everything. And when we don't pay them the equal pay that they deserve as their male counterparts, who are we cheating? Yes, we're cheating the individual worker, but more than that, we're cheating the kids that deserve to have that extra money in their household.
Almost two-thirds of mothers in the United States are either sole breadwinners or co-breadwinners of their families. About 42% of working mothers are the sole breadwinner of the family. They don't see the bump. In fact, fathers make more than non-fathers. Mothers don't get that kind of bump. Households headed by working mothers also more likely to be in poverty. About 1 in 4 households headed by a single mother are only 1 in 4 is economically secure. Conversely, single fathers are nearly twice as likely to have incomes that provide economic security. Eliminating pay inequity would cut the poverty rate for working single mothers nearly in half, from 28.9% to 14.5%. So if you eliminate the pay gap, you'd eliminate poverty amongst women almost in half.
I think it's important to note, because there's been this discussion about experience education. Let me just run down very, very quickly. 10 largest occupations for women: registered nurses, men's earnings $71,590, women $65,612. Now, in order to become a registered nurse, it would seem to me that you have to have the same level of education and experience, whether you are a man or a woman. Secretaries, administrative assistants, men 42.5, women 38.4. Elementary and middle school teachers, 55 for men, 50 for women. Customer service representatives, 37 for men, 32 for women. Accountants, auditors, 77 for men, 60,000 for women. I can go on. If you don't get to these positions without the kinds of education and experience that is relevant and that is equated, if you have the same experience as a man, as a woman, in order to achieve these. And I don't want to go on, but it does go on, which is really quite extraordinary. It is always that women are on the short end of the stick when it comes to education and when it comes to experience. Or one of the reasons in the past has been, women choose not to make as much money. That's a choice, that we just don't care about making as much money as men. Hogwash is what I say.
Thank you. I'll reclaim my time. I know that we're trying to move this meeting forward. And I'll say that maybe the reason why women are not filing complaints or filing lawsuits is the same reason why I chose to find another job and do something else. And that's, one, retaliation. I could continue there and be retaliated and probably talked about, and maybe my sales will go down, or blacklisted from the industry. There's no way, and I would much rather continue with my life and move forward. So those are, some real issues. Chairman Scott, pay parity also includes job classifications. So I look forward to coming before your committee with my 911 Saves Act. And with that, I yield back.
Mr. Woodall.
Thank you, Mr. Chairman. We talk about diversity in the workplace. We see the benefits of that no better than on this panel. How often have we sat in this room, Mr. Chairman, and pontificated about things that we wish we knew a lot about, but we don't know quite as much about them as we would like. To have someone like Mr. Byrne, who has been living this as a practicing attorney, and who sits before us today not to say there's no problem and so we don't need this bill, but who sits before us to say there's absolutely a problem, this bill just doesn't solve it. I think it would be a terrible mistake to let that expertise disappear. We've put him on the committees of jurisdiction for a reason, and we need to take advantage of that expertise. He's not asking that we derail this bill that does not solve the problem. He is asking that we make two of his amendments in order to try to make this bill just a little bit better, and I hope we will do exactly that. But I have no further questions.
Thank you. Ms. Scanlon.
Several of my colleagues have noted, equal pay for equal work has been the law of our country for quite some time, but like other countries, we've struggled to make it a reality. So I'm really heartened by a couple of the provisions in this bill that would do that. One of the barriers to actual pay equity is the difficulty for an employee who, by definition, has already experienced pay discrimination and then has to prove both that there are gender-based pay differences and that there's no legitimate reason for them. This bill shifts that burden to the party that has more access to information and more resources. Other countries have done this as well, notably Iceland back in January of last year, and they're seeing some results from that. The Paycheck Fairness Act also prevents retaliation against employees who share information about their wages, and that's a measure that increases their bargaining power. So I think both these provisions do move us closer to reducing that wage gap and with it the wealth gap, which has even more long-term consequences. And as a Philadelphia lawyer who has handled automobile accident cases in the past, I know very few lawyers who will accept a case for less than a 30% contingency fee. So I think this one-size-fits-all 20% contingent fee is going to have a really chilling effect. So that would be a problem, at least in my community. So thank you. For a response, that's fine.
Sure, I'll be quick. I know you're trying to. The truth of the matter is that there are many statutory causes of action under federal law where we have limitations on attorneys' fees, and there's still plenty of lawyers that come forward to file those cases and take those cases. So I hear what you're saying about personal injury law in Pennsylvania, which I don't know anything about, and certainly wouldn't second guess you about that. But I can tell you, practicing this area of the law, I think there are plenty of lawyers that would take these cases at a 20% contingency fee. Now, I understand that if you've got a $10,000 case, that might be a problem. We don't see $10,000 cases here. I've never seen a $10,000 case. If you want to see a $10,000 case, it's a class action where you've got 100 employees. And at that point, you don't have a $10,000 case, you've got a $1 million case or a $10 million case, whatever it is. And so that's where you see the lawyers come in. They say this is a pattern in practice with this particular employer, and we're going to come in here and not just hit them on this one employee, we're going to show what's happened throughout the whole company. And the 20% fee is very rewarding. So I don't know, I think personal injury cases and these sorts of statutory remedies are really apples and oranges.
Okay, and I understand that concern, but I think given the pervasiveness of the gender pay issue and the fact that it may not be a class action in every eventuality, and as Mr. Scott pointed out, that it is going to pose a problem for a lot of people who are already suffering from that inequity, I think the 20% cap probably is a little ambitious. But thank you. I yield back.
Thank you, Mr. Chairman. I apologize for being late. We had some Medicaid bills on the floor. But, Mr. Byrne, listening to you here reminds me of how grateful I was to have served with you on this committee and how much we miss your expertise. So thank you for being here today and bringing us these very, very thoughtful amendments. And, Mr. Chairman, I hope you will make those in order when the time comes, and I'll yield back.
Thank you very much, Dr. Mr. Morella.
Thank you, Mr. Chairman. Just very briefly, and I would not, I'm not a lawyer, I don't even play one on TV. So I wouldn't get into the various items that my distinguished and learned colleagues have mentioned, but I'm reminded of many, many years ago. You learn when I was in the state legislature, you can always explain a no vote. There hasn't been a perfect bill written in the long history of human endeavors. So you can always find something that you disagree with in a bill and hang a no vote on that. But in this case, and I want to thank certainly the sponsor of the bill and the chairman of the committee that I have the privilege of serving on, I think about it, people agree that this is a problem. People recognize that the data isn't in dispute. The disparities between women and men, and as my colleague has pointed out, particularly women of color and men, are accepted. People on both sides of the aisle will say this is a terrible situation that we find ourselves in. But I haven't heard of an alternative being offered. And I haven't heard of anyone trying to address this other than the folks here who are working very hard on this. So from my perspective, maybe there are better ideas out there. I haven't heard of them. Maybe this will be imperfect. I suspect in the 1960s, they probably thought, well, maybe we solved this problem. But that's what we do here. That's what we're expected to do, is to continue to observe, continue to measure, and to take action when appropriate to try to address dramatic disparities in our law and disparities in society. And I think this does it. And if it turns out that we find ourselves a year, 2 years, 3 years from now not having addressed what everyone acknowledges a problem, we come back and we do something different. I suspect Ms. DeLauro will be here and we'll have new ideas if this doesn't work. But I haven't heard of a better idea. And I would just like, in closing, on behalf of Arabella Stone and Harper Phillip, my two granddaughters, I want to thank you and hope this bill passes, becomes the law of the land, and we have real parity and pay equity in this country. So thank you, Mr. Chairman.
Ms. Lesko.
Thank you, Mr. Chairman, and thank you for everyone that's here today. And Ms. DeLauro, thank you for all your work on this. I know you've worked a long and hard time. I have a question for Mr. Byrne. And when I was preparing for this today, I looked up the statement from one of the witnesses in the House Subcommittee on Civil Rights and Human Services and the House Subcommittee on Workforce Protections. And on the back of it, it's a statement by Camille Olson. And on the back of it, there's an example of two people, a man and a woman. And I'm just going to read it out loud. It says, in this example, an employer has chosen to pay a higher salary to a female law firm office administrator who has a JD degree. The job duties for that position do not include legal work. Nevertheless, in the employer's judgment, the performance of those job duties will be enhanced by the additional qualifications of a JD, justifying the higher salary. So in this case, the woman has a JD, and the employer wants to give her a higher salary. But under a business necessity framework that is in this bill, that job-related reason may not qualify as a business necessity, as the job could be done without it, without the JD degree. So here we have a situation which is kind of reverse. And so you have the woman that has a degree, the man does not have that degree, the employer wants to pay the woman more, but in this case, my understanding, and I would like you to comment if I'm right, the man could sue and say, you know what, I need to get the same as the woman. So I'm just curious, And I know it could be reverse as well, but I'm just saying, is this a problem in this bill?
I think it is. By the way, we do know that over the last 10 or 15 years, there are more women getting baccalaureate degrees than there are men. And that, by the way, is getting more profound every year. So you could see where a woman would be getting more money because she has a baccalaureate degree, and a man who doesn't have the baccalaureate degree come in and say, well, I should be paid the same thing even though I don't have the baccalaureate degree. What that points out is that you're taking away from the employer, under this law, the ability to make a business decision. It's clearly a business decision. You can see where a law firm would want somebody in that position who has a JD and understands what's expected of a lawyer in a firm like that. So it's part of the problem with the way this law is written is it takes away from the employer the ability to take those sorts of things into consideration. The employer still has to show that it's not related to sex. But that amorphous standard is going to put everybody in a position where women can be in jeopardy here because of their increasing numbers of having baccalaureate degrees and men not. In fact, that's my prediction. Over years, you're going to see more males filing these claims than you do today. And I'm not saying that's a bad thing. I'm just saying we're about to interject into this a new standard that I think has actually got the potential to hurt women.
And Mr. Chair and Mr. Byrne, would your amendment address this problem
It would.
in the bill?
Yes, it would.
Perceived problem?
Yeah.
Thank you.
Ms. Shalala?
Thank you, Mr. Chairman. First of all, I want to congratulate both Congresswoman DeLaura and Congressman Scott on what I think is a bill that provides far more clarity. I do bring some expertise. I've run very large institutions which have had to deal with this issue with thousands of employees, and I'm basically an implementer. What this bill actually does is provide more clarity to people who are responsible, to CEOs, to managers, to presidents of universities, gives them a lot more clarity, and I think it will actually improve the situation because of that clarity. And so I strongly support the bill, and as someone who would have to look at this bill and implement it in large, complex institutions, I welcome this clarity and the opportunity to close a number of gaps. Thank you very much.
Well, thank you very much, and I want to thank all of our witnesses for taking the time to be here with us, and I'd like to remind you to give our stenographer your statements and anything else you'd like to put in the record. So, thank you all very much. Oh, great to have you back. Good to have you leave, too. Are there any other members who wish to testify on this legislation? Seeing none, this closes the hearing portion of our meeting. At this time, the chair will entertain a motion from the distinguished gentlewoman from California, Ms. Torres.
Mr. Chairman, I move the committee grant H.R. 7, the Paycheck Fairness Act, a structure rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor. The rule waives all points of order against consideration of the bill. The rule makes in order as original text for the purpose of amendment, an amendment in the nature of a substitute consisting of the text of the Rules Committee, print 116-8, modified by the amendment printed in Part 8 of the Rules Committee report, and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes in order only those further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, and shall be considered as read shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report. The rule provides one motion to recommit with or without instructions. Section 2 provides for consideration of H.Res. 124, expressing opposition to banning service in the armed forces by openly transgender individuals under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Armed Services. The rule provides all points of order against consideration of the resolution. And finally, the rule provides that the resolution shall be considered as read and shall not be subject to a demand for division of the question.
Well, thank you. As we just heard from the gentleman from California, the rule provides for consideration of H.R. 7, the Paycheck Fairness Act, under a structured rule. The rule self-executes a manager's amendment by Chairman Scott that makes clarifying changes. The rule makes an order 10, it was going to be 10, but I think we had a member just withdraw their amendment, so 9 amendments, each debatable for 10 minutes, and provides one motion to recommit. Additionally, the rule provides for consideration of H.Res. 124, the resolution expressing opposition to banning service in the armed forces by openly transgender individuals under a closed rule. You've heard the motion from the gentlewoman from California. Is there any amendment or discussion? Mr. Cole.
Mr. Chairman, I've got an amendment to the rule.
The gentleman is recognized.
Thank you very much, Mr. Chairman. My amendment would make an order, amendment number 14, offered by Mr. Byrne. It's critical that we actually make sure these judgments go to the victims of discrimination, not just to their lawyers. H.R. 7 has no limits on the percentage of the judgment that can be recovered by lawyers. So I think this is an important issue. I think Mr. Byrne made an important point and would urge the adoption of the amendment.
Thank you. We just heard the amendment from Mr. Cole. Is there any discussion on this amendment? Hearing none, the vote is on the gentleman's amendment. All those in favor signify by saying aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it. The
Roll
amendment is
call.
approved. The clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? No. Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? No. Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Mr. Burgess? Aye. Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
3 yeas, 9
The
nays.
amendment is not agreed to. Are there any other amendments? Mr. Lesko.
Thank you, Mr. Chairman. I have an amendment to the rule to make an order and grant the necessary waivers for amendment number 18 offered by Mr. Bost from Illinois. The underlying bill treats all companies in the same way. Those who have rigorous internal controls to ensure that they are complying with the law are just as liable as those that may actively discriminate. The Bost Amendment recognizes this backwards approach and would permit a company actively taking steps towards addressing pay differences to be penalized in a different manner than one that is not. I urge my colleagues to support the amendment.
Any further discussion on the Lesko amendment? Hearing none, the vote will be on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it.
I'd like a roll call vote.
The clerk, a roll call has been requested. The clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? No. Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Aye. Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
3 yeas, 9
The
nays.
amendment is not agreed to. Is there any other amendments or discussion? Hearing none, the vote will now be on the motion from the gentleman from California, Ms. Torres. All those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it. The clerk will call the roll.
Mr. Hastings? Aye. Mr. Hastings, aye. Mrs. Torres? Mrs. Torres, aye. Mr. Perlmutter? Aye. Mr. Perlmutter, aye. Mr. Raskin? Aye. Mr. Raskin, aye. Ms. Scanlon? Ms. Scanlon, aye. Mr. Morelli? Mr. Morelli, aye. Ms. Shalala? Yes. Ms. Shalala, aye. Mr. DeSaulnier? Aye. Mr. DeSaulnier, aye. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Burgess? No. Mr. Burgess, no. Mrs. Lesko? No. Mrs. Lesko, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
How is the gentleman from Georgia, Mr. Woodall, recorded?
Not recorded. No. Mr. Woodall, no.
Clerk will report the total.
9 yeas, 4 nays.
Motion is agreed to, and Ms. Torres will manage this for the majority. We'll do it for the minority, right? All right, so without objection, the committee stands adjourned.